taking meeting notes and let ClickUp AI Note Taker do it for you. It allows you to focus on your meetings, not your notes. It captures everything, from action items to key decisions.
To the impeachment panel. And that is precisely what our Kenyan system is, that you've had in the National Assembly, but you go for a trial in the Senate. That is the distinction between ourselves and South Africa. Your Lordship, on the issue of decisional independence of the judiciary, you have been told by the petitioners that that there was indeed a complaint filed in the Judicial Service Commission by the first petitioner, whereas that may be correct. If you look at the decision of Apollo Mboya versus Judicial Service Commission, petition number 204 and 218 of 2016, a decision by your brother Justice Korir, as he then was, this decision has talked very well about decisional independence of the judiciary, and if you get time to read it, you see that despite the first petitioner having filed a complaint in the Judicial Service Commission, it still did not warrant that he continues making attacks on the judiciary and the judicial officer in question. And that is covered very well in that decision. Therefore, your Lordships and my lady, that is the humble submission of the 9th respondent. We urge you to dismiss the consolidated petitions. Thank you.
My Lords, my lady, between please in the matter. My name is Milimo. I appear, my Lord, for the first respondent, as well as the 8th respondent, the Speaker, and the Deputy Speaker of the National Assembly. My Lord, my lady, I will be very brief. The first ground that I wanted to handle is a complaint against the Speaker that the proceedings were fast-tracked. And on that, I associate myself with the submissions of my learned colleague, Mr. Gumbo, that what the Speaker of the National Assembly did was simply to comply with the rules that had timelines, and that compliance does not amount to expeditious or fast-tracked disposal of the proceedings. And my Lord, my lady, we rely on the grounds of opposition that are dated 18th of October 2024, and the submissions that are dated the 20th of April 2026. Lord, my lady, I'm only left with one issue, which was alleged by the petitioners, that generally the Speaker was biased against the first petitioner. And I will demonstrate, my Lord, that that allegation is indeed untrue, and incorrect for the following reasons. Firstly, Lord, you shall note that the Speaker of the National Assembly does not participate in the proceedings of the House. The Speaker is merely a presiding officer of the House. And my Lord, that is the dictate of the Constitution under Articles 97(1)(d) and 106.
We've all been there, typing, deleting, retyping. Now I use Whisperflow. I just think out loud and it creates perfect formatted text on any app or website. Whisperflow understood what I was trying to say and gave me the exact output I wanted.
Impeachment proceedings are determined by a vote. And that vote is by members of Parliament. The Speaker of the National Assembly, at no point in time did he vote in these proceedings. In presiding over the House, my Lord, my Lady, the Speaker was undertaking a constitutional duty as prescribed by the Constitution. And under the standing orders of the National Assembly, the Speaker is expressly prohibited from voting. And although my learned senior Paul Muite, who has been a former member of Parliament, knows this, but just for the record, allow me to refer the standing order that so states that position, and that is Standing Order 69 of the National Assembly. And allow me to read, my Lord. It states, that is Standing Order 69(1), states that unless otherwise provided under the Constitution, a question arising in the House shall be decided by a majority of the members in the House present and voting. Then 3 says, on a question proposed for a decision in the House, the Speaker has no vote. The Speaker, therefore, does not participate in the decision making. And in this case, my lady, it was unfair for the petitioners to complain against the Speaker presiding over the House. The second point, and there was an allegation that the Speaker was biased because he's a member of the Kenya Kwanza coalition, and that by virtue of that association, therefore, he ought not to have presided over the House. My lady, my lords, you shall note that the mover of the motion presented the motion as an individual member of Parliament. The motion was never presented by the Kenya Kwanza coalition. And it did not matter, therefore, that any member of the House was associated with any coalition in the House. And more importantly, my Lord, my Lady, the first petitioner himself is a member, or was a member, of the Kenya Kwanza coalition. And if there was any favor then that would emanate from association, then he ought to have been a beneficiary. The association of either party to the coalition, my Lord, my Lady, you shall note that did not have any impact, as the voting was across the board, both by the members of the Kenya Kwanza coalition as well as the Azimio coalition. So association, therefore, did not matter. But more importantly, the mere fact that the Speaker of the National Assembly is associated with a coalition in the House is not unique. And that in itself does not amount to a biased presiding officer. And I'll give examples, my lord, my lady. In Tanzania, the Speaker of the Assembly is also a member of Parliament elected in a constituency. In Uganda, the same position applies. The Speaker of Parliament is also an elected member of Parliament. Again, in South Africa, my lord, the member of Parliament is elected as a Speaker of the National Assembly. And that applies everywhere, including even in the Kenyan Senate. The Speaker of the Senate is associated with a political coalition. And therefore, it's not unique for the Speaker of the National Assembly to be or to have association with a political party. He enjoys his right to participate or associate with a political party. The third allegation, or rather the allegation also about him being a biased presiding officer, you shall note that that allegation was never raised when the impeachment proceedings were presented before the House. That issue only arose when the pleadings were filed before this court. Yet, we've been told here that the first petitioner was represented or was accompanied by a battery of lawyers who appeared with him before the House. The raising of this issue, therefore, before you, my lady, my lords, is an afterthought. It's just for the mere so, but without any consequences. The other point I wish to raise on that, my lords, my lady, is that the Speaker of the National Assembly never commented on matters relating to the impeachment proceedings before or during the impeachment proceedings. He never made any comment whatsoever. His position was and still remains that he had no fight, he had no dog in the fight. He had absolutely no interest in the impeachment proceedings, and it's therefore unfair for the petitioners to complain for him merely having discharged his duty to sit as a presiding officer. The other complaint or issue that was raised about his biasness was in reference to a constitutional petition that I argued with my learned colleague Kibe, petition E202 of 2023, my lords, that had stated that the Speaker ought not be a leader of a political party. My lord, my lady, you shall note that that was not the ratio of that judgment. It was indeed an obiter, as it never formed part of the findings of that decision. But more importantly, the petitioners in that case had sought expressly that the Speaker be barred from presiding over the proceedings of the National Assembly, and that he again be removed as the Speaker of the National Assembly. All those prayers were dismissed by that court. None of them were granted. And in that decision, the Speaker of the National Assembly was never stopped from presiding over the proceedings of the House. And it therefore cannot be invoked as a decision to show that there was bias on the part of the Speaker of the National Assembly. Just to add, my lords, my lady, is that there's an appeal pending against that decision in the Court of Appeal, and we will be sorting ourselves out on that matter. The other point, my lady, that was against the Deputy Speaker, you shall note that the Deputy Speaker at no point in time did she preside over the proceedings relating to this impeachment. She never sat as a presiding officer. Her decision in respect of this matter was made through a vote that she was entitled to do as a member of parliament. Her views, therefore, whether for or against the impeachment proceedings elsewhere, could not have an impact in the decision that was taken by the House. And more importantly, my lord, my lady, is that none of the members of parliament complained that the views of the Deputy Speaker influenced the decision that was made by way of voting. Another point that I would invite the court to consider is that there's no prayer in the entire petitions that has been sought against the Speaker and the Deputy Speaker. Their involvement in these proceedings was for the mere so. And if it were that then the petitioners were true, that they had an issue with the Speaker and the Deputy Speaker, they ought to have sought a prayer against them. There's none whatsoever before you. What the petitioners are doing, my lord, my lady, is that they are shooting in the dark with a name that somehow they'll hit the target. Unfortunately, the Speaker and the Deputy Speaker cannot be a target in these proceedings because they had no fight. There's no dog in the fight. My lord, lastly, you realize that these are the same petitioners that had filed recusal applications against this court. And indeed, they had raised issues of bias.
What's the relevance of that line of argument?
I wish my line colleague would have waited so that I showed the relevance. My lord, that is a decision which is part of the record, and I don't need to cite it. All I was saying, my lord, my lady, is that the standards of recusal have already been established by this court in its recusal application and upheld by the Court of Appeal. And that the mere mention of the word bias, a four-letter word, and association by a party does not in itself constitute a reason to ask a presiding officer to recuse him or herself. And that does same reasoning, my lords, my lady, ought to apply here. And we seek that you find the allegations that have been laid against the Speaker and the Deputy Speaker to be without a basis, and they'd be dismissed. We associate ourselves with the submissions of our learned colleague for the respondents and the AG seeking that the petition be found without merit and that it be dismissed. That will be all, my lord, my ladies. I thank you.
Not yet, my lord. For the National Assembly. Very well, my lord. My name is Elias Ouma. I'll address you on two straightforward issues, namely, whether the sub judice rule under Standing Orders 89 of the National Assembly and Standing Orders 103 of the Senate could be interpreted to bar parliamentary proceedings on impeachment where judicial proceedings are still pending. My lord, from the very outset, it's our firm position that this court could not and should not interpret Standing Orders 89 of the National Assembly and 103 of the Senate to bar the National Assembly from deliberating impeachment proceedings in the disguise of sub judice rule. My lord, we take this position based on three arguments. First, the very standing orders is not absolute rule. The very standing orders that provide for sub judice is not absolute. Neither is it automatic. My lords, my lady, the standing orders establishes a two-limbed threshold which must be satisfied conjunctively for the same to be invoked. My lord, for clarity, permit me to read Standing Order 89, 1 and 2 of the National Assembly, which is pari materia with Standing Order 103 of the Senate Standing Orders. My lady, my lord, under 89.1, the sub judice rule is established. More critical to note is its applicability and its definition under 892. It says, a matter shall be considered to be sub judice when it refers to active criminal or civil proceeding and the discussion of such matter is likely to prejudice its fair determination. My lord, from that text, the word "and" is carefully crafted. It is deliberate and restrictive. It provides a mandatory conjunctive element that for the preceding statement to ensue, then the petitioners ought to have established a level of prejudice. My lord, why do we say so? The Court of Appeal, and this is a decision we have cited in our supplementary list and digest of authorities, in Korir versus Republic, Criminal Appeal number E52 of 2023, had a chance to define the meaning of the word "and" when used in a statute. My lord, if you go through that decision, you will note, and with reference to this standing order, that for sub judice rule under 89 to be invoked, there must exist an active proceedings before a court of competent jurisdiction. Secondly, and more critically, there has to be a demonstrable likelihood of prejudice. Who then has the burden of proving this prejudice? And that takes me to my second argument. My lords, my lady, it's our submission that the petitioners at the time of trial in the Senate and the National Assembly had the burden of providing, by way of evidence or demonstration or through a preliminary objection at the National Assembly at a preliminary stage, the level of prejudice to demonstrate that the discussions and the debate on impeachment could actually impair administration of justice in the impending cases. Worth noting, my lords, my lady, in your previous ruling, this very bench provided the remit within which this court can intervene during impeachment. Those decisions are your decisions. And that's the reason why this issue was not raised in the National Assembly.
This isn't just food. This is survival. In Gaza, a single warm meal can mean everything. It means strength for a mother, hope for a child, and one less night of hunger for a family. Our teams are on the ground,
and the constitutional doctrine of separation of powers, as submitted by my learned senior and pupil master, Mr. Eric Gumbo, under Article 95(5) of the Constitution of Kenya, it is the National Assembly, not courts, not executive, not commissions, that has the mandate of initiating the process of impeaching the Deputy President. What does that mean, my lords, my lady? Under the doctrine of separation of powers, the rubrics of doctrine of separation of powers, and this has been cited in our list and digest, the Supreme Court in Mate, Justice Kariuki Mate and another, versus Martin Nyaga Wambora and another, 2017 EKLR, at paragraph 63. The court set the parameters within which various state organs must function. It provided 5, but of critical is number 3. The court said that each arm of government is under duty to refrain from directing or interfering with another organ on how to exercise its mandate. To the extent that the issue of impeachment and initiation thereof is a preserve of the National Assembly, then this court should not be invited, in disguise of sub judice rule, to interfere with the functions of the National Assembly. My Lord, any contra-interpretation would allow litigants in future to weaponize the judiciary to protect public officers who should be accountable as submitted by my pupil master and who should be held accountable under Article 145 of the Constitution. Because of time, my lord, my lady, I'll take you through the second issue, which is also rather straightforward and raised by one of the petitioners. That is whether the participation of Honorable James Orengo, Senior Counsel, as sitting governor, and Honorable Tienda Amolo, Senior Counsel, as member of the National Assembly, created a conflict of interest and undermined the fairness of the impeachment proceedings. My lords, my lady, first, it's our submission that there is no constitutional or statutory bar that will prevent an otherwise qualified advocate to represent a party either in court, tribunals, or quasi-judicial commissions. The only exemption that exists is where there are conflict. As submitted by Manad Senior, conflict requires evidence. Conflict must be demonstrated. It's our submission that the petition has failed to demonstrate by way of evidence that the participation of Honorable Orengo and Honorable Tienda Molo would prejudice and or result to an impaired proceedings during impeachment. More important to note is that this very issue has been determined by a court of equal status in John Okello Nagafwa versus Independent Electoral and Boundary Commission, 2013 EKLR. What did the court say, my lord? The very subject individual was subject of that petition, that is Honorable Orengo. At paragraph 27, this is what the court said. The petitioner has not demonstrated before this court that Orengo has used public time in preparing for and participating in this election petition. No evidence has been shown to the court demonstrating that counsel's conduct this far is inherently incompatible or fundamentally in conflict with this role as a member of Senate. My Lord, it is the petitioner's contention that the participation of these state officers contravened Article 77 of the Constitution. What does Article 77 of the Constitution say, my Lord, my lady? Article 77(1) says that a full-time state officer shall not participate in any other gainful employment. My Lord, to give effect to this provision, Parliament enacted Leadership and Integrity Act. That act was repealed, but it was in operation at the time of impeachment of one Rigathi Gachagua. My Lords, my lady, under Section 26 of that act, there is a definition of a gainful employment, and for that provision to apply, there's a condition that must be demonstrated by the petitioners, and that is Section 29(2). It defines gainful employment to mean work that a person can pursue and perform for money or other form of compensation or remuneration, and this is where it's important to note, which is inherently incompatible with the responsibilities of the state office or which results in impairment of the judgment of the state office. The petitioners are saying that the participation of Honorable Orengo resulted to gainful employment, but they have not given you any evidence to show how it impaired the judgment of these state officers. My Lords, my lady, it is the rule of the thumb that he who alleges must prove. All the petitioners are saying are speculations, and they are not anchored on any basis. On that ground, we urge you to dismiss their issues as raised in their petitions. I'm most obliged, my lady.
I think before you sit down, the citation you are given about Senator Orengo, I think you picked and you choose what you wanted. There are issues on that issue.
Yes, my lord.
Look at the case of Manduku versus PPP. I did it myself and I made comments on that. I think in order to the court, although we are not bound by our decisions, we should be studied enough to say that there's also another case where some issues arose, and this is what the court said.
Yes, my lord. Just to distinguish that, my lord,
Why did you not say
I'm much glad, my lord. Most obliged, my lord. Most obliged.
It's 2 o'clock. I think we should take a rest and then come back at 3.
Let's take them.
Just tie them up.
No, but
We want us to leave them.
Yeah? No, we can leave them here and let them
We have
leave.
good numbers. We are 3 of us, so we can very easily carry.
Let's tie up.
That one is not ours.
Simu ya aina gani?
Kuna sema
This is the first time you've come here to give me a gift. It's very important. I have to cherish it.
Whatever. Just don't hang a bunch of lights on it.
I feel guilty. I selfishly wanted to be with Miss Leo's daughter, and I got a reward. Sorry, that wasn't funny.
You're pretty weird. You wanted to be my boyfriend straight off. And even after I gave you a hard time, you still didn't give up. You should have been arrested for harassment.